afternoon session entitled Crash Course, What Happens After Criminal Inadmissibility is Triggered is about to start. We're going to have a short presentation about reporting requirements first and then go into some other things that happen after criminal inadmissibility is triggered, fairness letters, Section 44 reports. And we're first going to hear from Lawyer Laura Setzer. So Laura has been practicing exclusively in the area of immigration and refugee law since 1993. She obtained her law degree from Osgoode Hall Law School in 1991. She was called to the Ontario Bar in 1993 and became a solicitor of the Supreme Court of England and Wales in 1994. Laura has been a sole practitioner in Ottawa since 2005. She appears regularly before the Immigration and Refugee Board and the Federal Court. She represents clients in detention reviews, refugee hearings, federal court applications for judicial review, humanitarian and compassionate grounds applications, sponsorship appeals, and independent applications for immigration to Canada. She's a member of the Legal Aid Ontario Area Committee, the Refugee Lawyers Association, and the Canadian Association of Refugee Lawyers. So welcome, Laura, and thank you so much for being with us. And because the sound is getting a little drowned out by this event, we're just going to mic you up.
Okay, so I'm going to get us started with a little bit about reporting requirements. So we're basically now into what happens after inadmissibility is triggered. So once inadmissibility is on the table, then the person is going to be on the radar of the Canada Border Services Agency, the enforcement branch of immigration. So CBSA is going to want to know where they are. They're going to want to tell them what they can and can't do. And this is accomplished by establishing conditions they have to comply with. So this will sound very familiar to criminal law practitioners. So reporting requirements can come about in two ways. First, initiated by Canada Border Services Agency. And the second would be put in place by the Immigration and Refugee Board. And generally that'll happen when someone comes off criminal hold and is held in detention by immigration, and then you'll get the whole detention review process, which I think we're going to hear about maybe tomorrow, kind of like our immigration bail hearing. And the decision maker in that setting can release a person, but also establish terms and conditions they have to comply with. So I think one of the first, I guess a good point to make is that when you hear your client say, oh, I have to go to an appointment at CBSA, they called me in for an appointment, make sure the client goes. I know they're always afraid, they don't know what's going to happen, but if they don't go, it can get a lot worse for them. It's failure to attend one of these appointments can then be used as grounds to either detain them or maybe keep them in detention longer on the basis that they're not complying with, they're not reporting, they're not complying with immigration. CBSA's conditions that you'll generally see, and I'm going to get a written copy of this. They're again going to sound very familiar to you. Keep the agency informed of your address and let us know if you're going to move in advance of moving. Sometimes CBSA wants to know the name of your employer because of your employment. If you're not already under a condition to report to CBSA, you may be asked to start reporting. And reporting requirements can be in place for a report maybe once a month. They can be once a week. It depends how much supervision CBSA wants to have over you. There'll be a condition to report as required to CBSA, to any proceeding. Passports. A person will be asked to hand over their original passport, and if they don't have a passport, they'll be asked to apply for a passport from their home country. If there's no removal order in place, the person can keep their passport. A copy will have to go on file with CBSA, but if there's a removal order in place, they will have to hand over their passport. And that's really how CBSA is going to know where they are and know what they're doing. Then the conditions that are generally also put in place are the ones to do with criminal charges and convictions. Don't commit an offense under an act of parliament. If you are charged with an offense, report that to CBSA without delay. If you're convicted of an offense, report to CBSA without delay. If you intend to leave Canada, perhaps you haven't handed in your passport, you're also supposed to advise CBSA. CBSA has the power to arrest and detain a person where there are reasonable grounds to believe they're inadmissible and they're a danger to the public or they're unlikely to show up for a proceeding. So again, not showing up for that CBSA interview can be used there to say, well, they didn't come for that appointment, they're not going to show up for something more serious. Once a person's in immigration detention, like I said, the terms and conditions can be put in place by the Immigration and Refugee Board. It's the Immigration Division within the umbrella of the Immigration and Refugee Board. And the Immigration Division has even broader powers to impose conditions on the person. I think their mandate is something like whatever is considered necessary to make sure that the person complies, and that covers anyone who's either the subject of a report on inadmissibility, who's the subject of an admissibility hearing, or who already has a removal order. So the kinds of extra terms and conditions you might see imposed by the Immigration Division, and I think we'll talk more about that in the detention review, would be things like a curfew, or don't just tell us about your address, we're going to tell you where you are going to live and with whom you're going to live. Avoid drugs and alcohol. They can get broader than that, but we'll hear about that more tomorrow. Bonds people as well. Conditions that are put in place apply to the client until they've either been changed or they've been canceled. Sometimes we're able as immigration practitioners to write and request changes to the terms and conditions. If CBSA is the person who decides, we make our application to CBSA, or if it was the Immigration Division member who put these terms and conditions into place, we can write a request to them. Often it's about changing maybe reporting requirements. If a client has a really onerous reporting schedule and it doesn't fit with perhaps their work, that's a way to say, look, this client just cannot take 2 hours off of work once a week to travel all the way to your office to sign in and then go back to work. So sometimes we can get them modified. So unless there's a specific condition for a person to advise CBSA of a charge or conviction, they don't have to do it. But CBSA always find out about these things. We were talking about that earlier. So in terms of refugee claimants, CBSA also imposes conditions on refugee claimants. They're not always so aware of it, but it happens when they enter Canada or when they make their refugee claim. Because when they enter Canada, they are issued with removal orders. They are found inadmissible for seeking to enter or remain in Canada without the right visa, or for failing to comply with the Act. Now that removal order is put into place. It's not enforceable because it's sort of put aside while they go through the refugee determination process, but it is there, and it gives CBSA the authority to put in place terms and conditions. So they're going to have terms and conditions again, and they're going to be those basic ones again. Address, probably not reporting conditions unless CBSA is worried about them, worried about their identity or whatever, but definitely address, and they have to report criminal charges or criminal convictions. If someone is already in the country and then they make a refugee claim, perhaps they're here as a student or a visitor, they make a refugee claim. What's going to happen then is that they're going to have their passports taken, and the conditions are going to be imposed at that point. Probably go to an inland office, and then they'll be sent to CBSA for those terms and conditions to again be put into place. So yeah, those are basic reporting requirements.